Hey everybody, this is Chris at Punchwork. Let's talk today about the Pregnant Workers Fairness Act. Before the PWFA was passed, the ADA, the Americans with Disabilities Act, didn't protect all pregnancy-related conditions. But now the PWFA is the law. So it's the Pregnant Workers Fairness Act, the PWFA. And it protects workers who are pregnant, recently gave birth, or have a medical condition as a result of being pregnant or having given birth. So the PWFA, the Pregnant Workers Fairness Act, requires employers to give a reasonable accommodation when you have a qualifying health condition. When you're pregnant, when you've recently given birth, you ask for a reasonable accommodation and your employer is required to give it to you under the PWFA. What could those accommodations look like? Well, one, it could be that you can sit and not have to be standing all day. You could ask for more frequent breaks. You could ask for water at your workstation. Time off for doctor's appointments. This is a big one. If you're pregnant or recently given birth, you're going to have some doctor's appointments. I mean, obviously. And you can also ask for modified tasks. Again, the PWFA says when you're pregnant or you recently gave birth, you can ask for reasonable accommodations and your employer has to give them to you. So here's what's important about reasonable accommodations. They're not special favors. They're required. Just because you're pregnant, you shouldn't be concerned about getting your pay docked or being punished for missing work for doctor's appointments. You shouldn't have to worry about missing work or not being able to do as much work. Reasonable accommodations are required under the law. If you don't get them, that's something that you can call a lawyer and you can do something about. All right, so if you're an employer or you're talking to your employer, here's what's important to know about the PWFA. Number one, the employer has the duty to engage in the interactive process. What does the interactive process mean? It means that the employer cannot ignore requests from your employee about time off, about a reasonable accommodation. It means that it has to be interactive. You can't force it yourself if you're the employer. You have to talk to your employer. It has to be interactive. If you're the employee and you ask for reasonable accommodation, your employer has to get back to you. They can't ignore your email. They can't miss your meeting, refuse to talk to you. It's got to be interactive. And as a result of the interactive process, the employer has to provide a reasonable accommodation. It doesn't have to be the exact accommodation that the employee requests. You have to interact and work through that together. But at the end of the day, the employer has to, number one, engage in the process. And number two, it must provide a reasonable accommodation. And just because that accommodation is inconvenient or requires a little more work doesn't mean you can get out of it if you're the employer. The only way you can get out of an accommodation and show that it is unreasonable is if it imposes an undue hardship. And this is probably obvious, but those are two words. It's not just a hardship. Any kind of accommodation is going to be harder for the employer. It's an undue hardship that gets an employer out of a reasonable accommodation and makes it unreasonable. So at the end of the day, the employer has two obligations here. They've got to engage in the interactive process and they've got to provide a reasonable accommodation. So I want to give more details about the PWFA. We're filming this, it's 2026. You have rights. Let's talk about some of those. It's not okay at work under the PWFA if your employer makes you pump in the bathroom all the time, puts you aside, doesn't give you a reasonable accommodation. It's not okay. It's 2026. It's not okay that you're just sitting in your car, that you're not getting time off. That's not okay. It's not okay to deny you breaks. If you're pregnant, you probably need breaks. That's okay. It's not okay for your employer to punish you for asking for a reasonable accommodation. Again, it's 2026. The PWFA is the law of the land. It applies. Know your rights. So you know your rights. Here's what to do about them. Number one, and this is most important, document literally everything. Who said what, when they said it, where it happened. Create notes, create emails, save text messages, screenshots, document everything. People's stories will change later. That just happens. But you gotta document everything. And you gotta remember, pregnancy, it's not a workplace inconvenience. Again, the PWFA is the law of the land. You're not inconveniencing someone when you ask for a reasonable accommodation. You're exercising your own rights. It's not the company's rights, it's not the employer's rights, it's your right to a reasonable accommodation. It's their obligation to engage in the interactive process. And when they don't do that, you want to come with your receipts. You want to come with your documents to prove it. Here at Punchwork, we can help you with that. To sum it all up, the PWFA protects you. Don't sleep on your rights. Here at Punchwork, we have a lot of educational content like this. Please like, subscribe, and follow for a lot more. We want you to know your rights. Most importantly, we don't want you to sleep on them. We want you to exercise your rights. They're yours.